A gun gets stolen out of an unattended car in Virginia. A year later, that same stolen handgun ends up at Old Dominion University, where it is used in a shooting that kills one person and injures two others. That single traceable chain of events, from an unlocked car to a campus shooting a year later, became the specific case lawmakers pointed to when Virginia passed a new law this year, making it a crime to leave a handgun visible in an unattended vehicle. If you drive with a firearm in your car in Virginia or anywhere else, the actual rules governing how you can legally do that vary more by state and carry more real consequences than most gun owners realize, and getting them wrong is not a hypothetical risk. It is exactly the kind of mistake that shows up in real arrest reports and real civil penalties every year. Let's walk through exactly what changed in Virginia and exactly what the real, current rules are everywhere else, because this is one area of gun law where a wrong assumption can turn a routine drive into a criminal charge. Quick thing before we get into it. I cover the actual state and federal statutes governing gun ownership, not the recycled headline version. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into exactly what changed and what the real rules are. Let's start with Virginia because it just became one of the more instructive examples of how quickly this specific area of law can change. House Bill 110, part of a broader package of roughly 24 firearm bills that passed Virginia's General Assembly this year and were signed by Governor Abigail Spanberger, prohibits leaving a handgun visible inside an unattended motor vehicle. The law carries a civil penalty of up to $500, meaning it is not a criminal charge in the sense of jail time, but it is a real enforceable fine, not just a suggestion, and it applies regardless of whether the firearm is ultimately stolen or not. The violation is leaving it visible and unattended in the first place, independent of what happens afterward. The bill's supporters pointed directly to a specific documented incident, a handgun stolen from an unattended vehicle that was later used in a shooting at Old Dominion University in March of 2026, killing one person and injuring two others, as the exact kind of preventable chain of events this law is meant to interrupt at the source, tracing a stolen .22 caliber handgun taken from a car roughly a year before the shooting, all the way to that specific fatal outcome. Worth knowing, during the legislative process, lawmakers considered and ultimately rejected a proposed carve-out that would have exempted members of the General Assembly themselves from this exact law, a detail Republicans specifically raised as an objection during floor debate, meaning the rule that passed applies uniformly without a special exception for the lawmakers who wrote it. A detail worth knowing if you ever hear a claim that legislators exempted themselves, because in this specific case, that attempt was made and specifically voted down before final passage. This Virginia law is part of a much larger package worth understanding in context, because vehicle carry rules rarely exist in isolation from everything else changing around them. The same legislative session produced Senate Bill 749, banning the future sale of certain semi-automatic rifles and high-capacity magazines, effective July 1st, along with a higher minimum purchase age for handguns and certain rifles, expanded locations where carrying is prohibited entirely, and tighter home storage requirements for households with children, including new rules recognizing firearms rendered inoperable with an approved locking device as compliant secure storage. Virginia's own assault weapons ban is currently tied up in multiple lawsuits and blocked by court injunctions in several jurisdictions, a genuinely unsettled piece of that broader package. But the vehicle visibility law is a separate, distinct measure and is not currently caught up in that same litigation, meaning it is expected to take effect as written on July 1st alongside the rest of the package, regardless of how the assault weapons litigation ultimately resolves. It is worth understanding why these two pieces of the same package ended up in such different legal positions. The assault weapons ban restricts a broad category of property ownership going forward, which triggers the full weight of Second Amendment litigation under the historical tradition test the Supreme Court established in Bruin. The vehicle visibility rule restricts a narrow behavior, leaving a specific item visible and unattended closer in legal character to a safe storage requirement than an ownership restriction, which is part of why it has not attracted the same kind of constitutional challenge that immediately followed the rifle and magazine ban. Now let's zoom out to the rest of the country, because Virginia's new rule is really just one specific version of a question every state answers differently, and getting it wrong in the wrong state carries real consequences. There is no single nationwide rule for how a firearm has to be carried in a vehicle. States generally fall into a few different categories. Some states allow a loaded, concealed firearm in a vehicle for anyone legally eligible to own one, without any additional permit required specifically for vehicle carry, treating your vehicle essentially as an extension of the same rights you have at home, a category that includes most states with permitless or constitutional carry laws already in place. Other states require the firearm to be unloaded and either locked in a separate compartment like a trunk or otherwise rendered genuinely inaccessible from the passenger compartment while you are driving, a stricter category that includes several of the same states with broader restrictions on firearm ownership generally. Still others draw a distinction between open and concealed carry within a vehicle specifically, allowing one but not the other, or requiring a permit for one but not the other, an approach that can trip up even careful gun owners who assume open and concealed carry are treated identically everywhere. Texas, for example, generally allows a firearm to be transported in a vehicle either concealed or, for license holders, openly, without it needing to be in a separate locked container, though prohibited locations like schools and courthouses still apply with a federal buffer zone layered on top in some cases, specifically a 1,000-foot radius around school property under the Federal Gun-Free School Zones Act, an area where even a valid Texas license to carry does not exempt you from that federal restriction while on foot, though it does exempt you while remaining inside your vehicle passing through that same zone. Illinois takes a notably different approach for non-residents specifically. A visitor with a valid carry permit from their home state can legally transport a loaded concealed handgun within their vehicle under Illinois law, but the moment they exit that vehicle, the firearm has to stay locked inside and out of plain view. And Illinois also requires you to proactively notify an officer of the firearm's presence during any stop, a requirement that does not exist in every state and that catches out-of-state travelers off guard more than almost any other single rule in this area. Illinois additionally imposes its own 15-round magazine limit for handguns specifically, meaning a magazine that is perfectly standard and legal in a neighboring state can itself constitute a separate violation the moment you cross into Illinois, entirely apart from whatever rule governs the firearm itself. California adds yet another layer worth knowing if your route takes you through it, generally requiring a firearm in a vehicle to be unloaded and stored in a locked container or the trunk, unless you hold a valid California carry license, a stricter default than many neighboring states, and one that treats an unlocked glove compartment as insufficient even if the firearm itself is otherwise legal to own. This state-by-state patchwork is exactly why federal law includes a specific safe passage protection for interstate travel, and it is worth understanding precisely because it protects you in a narrower way than most people assume. Under 18 U.S.C. Section 926A, if you are legally allowed to possess a firearm both at your starting point and your destination, you are entitled to transport that firearm through states in between, even states where you would not otherwise be allowed to possess it, as long as specific conditions are met during the actual transport. The firearm has to be unloaded. Neither the firearm nor any ammunition can be readily accessible or directly accessible from the passenger compartment, meaning tucked in a locked trunk or a separate locked container is the safest way to satisfy this, not simply out of sight in a glove compartment. If your vehicle does not have a separate trunk compartment at all, the firearm and ammunition still have to be in a locked container other than the glove compartment or center console. This protection exists specifically for genuine transit, passing through, not extended stops, and courts have generally read it narrowly, meaning stopping for the night in a restrictive state, running errands, or otherwise deviating from continuous travel, can weaken or eliminate this specific protection. So the safest practice, if you are genuinely just passing through a restrictive state, is to minimize stops and keep the firearm locked, unloaded, and inaccessible the entire time you are in that state. Let me clear up a few misconceptions about this federal protection specifically, because relying on a wrong assumption here is exactly how a routine trip turns into an arrest. The first misconception is thinking this federal law overrides every state law you might encounter along your route. It does not. It is a narrow affirmative defense you have to actually qualify for by meeting every one of its specific conditions, not a blanket shield that makes state law irrelevant the moment you cross a border. Some states, New Jersey among them, have had well-publicized cases where travelers genuinely believed this protection applied to them and were arrested anyway because a specific condition, like keeping ammunition separate or the firearm fully inaccessible, was not strictly met. The second misconception is assuming a permit from your home state, even a strong one, does any work here at all. It does not. This specific federal protection has nothing to do with concealed carry permits or reciprocity. It is a separate transport provision that applies regardless of whether any state recognizes your permit. The third misconception is thinking a brief stop, gas, food, a bathroom break, automatically breaks this protection. Courts have generally allowed genuinely brief, necessary stops without treating them as ending your transit. But the safer practice is always to minimize any deviation from continuous travel and keep the firearm secured exactly as required the entire time, since the exact line between an allowed brief stop and a disqualifying delay has been litigated inconsistently across different courts. Here's the practical action plan if you regularly drive with a firearm, whether in your home state or across state lines. First, confirm your specific home state's actual rule for vehicle carry directly through your state's own official statutes, not a general assumption based on what a neighboring state allows, since even states that seem similar on gun rights broadly can differ sharply on this one specific point: loaded versus unloaded, locked versus simply concealed, permit required versus not. Second, if you are traveling through multiple states, map your entire route in advance and check each state's specific vehicle carry and magazine capacity rules, since a magazine that is perfectly legal in your home state can itself become a separate violation the moment you cross into a state with a lower capacity limit, entirely independent of whether the firearm itself is legal there, a distinction that trips up travelers who correctly research the firearm rule but never think to separately check the magazine rule. Third, if you are relying on the federal safe passage protection specifically, keep the firearm unloaded and locked in a genuinely inaccessible location for the entire duration you are in a restrictive state, and avoid unnecessary stops, since this specific protection is interpreted narrowly by courts and does not function as a blanket shield the moment you step outside a moving vehicle. Fourth, if you live in Virginia specifically, adjust your habits starting July 1st, a habit that was perfectly legal for years. Leaving a handgun visible on a seat or in a cup holder while running into a store becomes a $500 civil penalty the moment this law takes effect, regardless of whether anyone actually steals the firearm. So the simplest compliance step is simply making a habit of placing any handgun out of sight, in a glove box, console, or under a seat every single time you step away from the vehicle, even briefly. Fifth, regardless of which state you are in, remember that an unattended visible firearm is a theft target independent of any specific law requiring you to hide it, meaning the practical safety reasoning behind Virginia's new rule applies as good general practice even in states with no such legal requirement at all. Since a stolen firearm becomes untraceable to its original lawful owner the moment it changes hands illegally, exactly the chain of events that led to the Old Dominion University shooting a full year after the original theft. Step back and look at what this Virginia law actually represents in the bigger picture of vehicle carry regulation nationally. It is a genuinely narrow, specific rule. It does not restrict who can own a firearm. It does not restrict carrying one in your vehicle at all. It restricts one specific behavior, leaving it visibly unattended, tied directly to a documented case where exactly that behavior led to a stolen firearm being used in a fatal shooting a year later. Whether you think that specific policy response is the right one is a separate question from understanding what the law actually requires, and getting the second part right matters regardless of where you land on the first. It is also worth noting that Virginia is not the first state to pass some version of this rule. Several other states already restrict visible, unattended firearms in vehicles in some form, and given how directly this measure traces back to a specific, well-publicized shooting, it would not be surprising to see other state legislatures point to Virginia's law as a model if a similar incident happens elsewhere, the same way several of Virginia's other 2026 measures borrowed directly from laws already on the books in states like Maryland, California, and Connecticut. There is a broader lesson here worth carrying beyond Virginia specifically. Vehicle carry law is one of the areas of gun regulation most likely to change quietly, without the same national attention that a rifle ban or a Supreme Court case attracts, precisely because it usually takes the form of a civil penalty rather than a felony, and because it typically responds to a single local incident rather than a broad national debate. That makes it exactly the kind of rule a careful gun owner can miss entirely. Right up until the moment a routine stop turns into an unexpected fine, which is exactly why checking your own state's current specific rule directly, rather than relying on what was true 5 years ago or what a neighboring state requires, is worth doing today rather than after the fact. If this helped you understand the actual rules instead of guessing based on what you assume applies everywhere, hit like so it reaches other gun owners who drive across state lines without realizing how much this specific rule varies, and subscribe if you have not, because I will keep tracking how Virginia's new law is actually enforced once it takes effect, along with any other state that follows with a similar measure in response to its own local incident. This is exactly the kind of quiet, state-by-state legal change that never gets a dramatic headline, but genuinely affects daily habits for millions of gun owners, and it deserves the same careful tracking as any higher-profile Supreme Court ruling. Tell me in the comments which state's vehicle carry rule surprised you most, because that tells me exactly which state to break down in more detail next, and whether you would find a full 50-state comparison video useful as a follow-up to this one.